Hello dear students, today we will discuss the legislative relations. The objectives of this lecture are legislative relations between the Union and the states with respect to territory, legislative relations between the Union and the states with respect to subject matter, dominant position of Union in respect of legislative powers vis-a-vis states, approach of judiciary in interpretation of legislative powers. The Constitution effects a clear-cut division of powers between the Union of India and the states. Part 11th and Part 12th of the Constitution from Article 245 to 263 deal with the relations between the Union and the states. Part 11th deals with the legislative and administrative relations between the Union and the states, while as Part 12 explains the financial relation between the Union and the state. Dear students, Articles 245 to 255 of the Constitution deal with the legislative relations between the centre and the states. The Constitution in its Part 11 lays down the legislative relations between the Union and the states. Distribution of legislative powers between the centre and the units is an essential condition of federal type of government. The Constitution of India adopted the scheme of distribution of powers from the Government of India Act 1935. The legislative relations between the Union and the states can be studied under two main headings. First, legislative relation with respect to territorial jurisdiction. From the territorial point of view, under Article 245, Clause 1, Parliament is empowered to make law for whole or any part of territory of India. A law made by the Parliament is not invalid because it has extraterritorial operation. Similarly, state is empowered to legislate for the whole of the state. The question of extraterritoriality arises in case of law made by the state legislature. To determine the question whether the particular state legislation is within the territorial limits or not is decided by applying the theory of territorial nexus, or we can say doctrine of territorial nexus. State laws can be challenged on the ground of extraterritorial operations, for a state legislature can make laws for the state concerned. The doctrine of territorial nexus implies that the object to which the law applies need not to be physically located within the boundaries of the state. It is enough if it has sufficient territorial nexus or connection with the state. This doctrine is generally involved in tax cases. A very good illustration is furnished by Wallace Brothers and Company Limited versus Income Tax Commissioner, a pre-constitution case. In this case, the appellant company was incorporated in England and had its registered office there. One of the partners carried its business in British India. The company made an overall profit of 2.4 million, out of which 1.7 million accrued in India. It was held that India could levy income tax on the entire income of the company, for there was a sufficient territorial nexus between India and the company. For the application of the doctrine of territorial nexus, two essentials are to be proved. One, the connection between the object sought to be taxed and the state seeking to tax must be real and not illusionary. Second, the liability sought to be imposed must be pertinent to that connection. In the case of State of Bombay versus R.M.D. Chamar Bhagwala, State of Bombay, by invoking Bombay Lotteries and Prize Competition Control and Tax Act 1948, sought to tax prize competitions, including those contained in the newspapers printed and published outside the state of Bombay. The petitioners conducted prize competition called RMTC crossword through a newspaper supporting Star, which was printed and published at Bangalore in state of Mysore. Entries for the crossword were received from various parts of the country, including state of Bombay. The petitioner challenged the validity of the act on the ground that state overstepped the limits of its legislative field as it purported to affect persons residing and carrying business outside the state. The Honorable Court observed that there was sufficient nexus to justify the taxation. Now, we shall move towards another aspect, which is the scope and the extent of the Parliament to legislate extraterritorial laws. It was recently considered in the case of GVK Industries Limited versus Income Tax Officer. Court ruled that because of interdependence and the fact that many extraterritorial causes have an impact or nexus with India and should be deemed to be within the legislative competence of national parliaments as being limited to only those aspects or causes that arise within the territory of nation state. It would be impossible to conceive legislative powers or competence of national parliament as being limited only to the aspects or causes that arise, occur or exist or may be expected to do so within the territory of its own nation state. Constitution imposes affirmative obligation on all the organs of the state to protect the interests, welfare and security of India. Parliament is empowered to enact such laws that serve such purposes. Hence, those even extraterritorial aspects or causes, provided they have nexus or connection with India, should be deemed to be within the legislative competence of the Parliament, except to the extent the Constitution itself specifies otherwise. Thus, the present-day constitutional jurisprudence regarding enactment of extraterritorial legislation by the Parliament, the courts recognized that none of the cases stand for the proposition that powers of the Parliament are unfettered and that our Parliament possesses the capacity to make laws that have no connection whatsoever with India. An interesting issue was considered in the case of State of West Bengal versus Committee for Protection of Democratic Rights, wherein an objection was raised regarding the exercise of power by High Court under Article 226 of the Constitution. The objection was based on the doctrine of distribution of legislative powers between the centre and the states. It pertained to the direction given by the court for investigation of a case by CBI without the consent of the state in which the offence was committed. The court considered the issue when the scheme of the Constitution prohibits encroachment by the Union upon a matter which exclusively falls within the domain of the state legislature, like public order, police, and the third organ of the state, viz. The judiciary, directs CBI, an agency established by the Union to do something in respect of a state subject, to investigate a case without the consent of the state government concerned. The court ruled that from a bare reading of the constitutional provisions, it was manifest that the legislative power of the Union to provide for the regular police force of one state to exercise power and jurisdiction in any area outside the state and can be exercised only with the consent of the government of that particular state. However, the restriction imposed on the powers of the central government does not apply mutatis mutandis to the constitutional courts. Now, the distribution of legislative power with respect to subject matter, or you can also call it distribution of legislative subjects. The distribution of legislative powers between the centre and the state is the most important characteristic of federal constitution. The distribution of powers between the Union and the states is contained in the three lists: the Union list, the state list, the concurrent list. Under 7th schedule of the Constitution, certain powers are exclusively allotted to centre, certain exclusively for the states, and certain areas wherein both of them can operate. The Union list is the longest of the three lists. It lists 97 subjects on which the Union Parliament can pass a law in accordance with the procedure laid down by the Constitution. The Union list has 99 entries. The main subjects contained in the Union list include defence, foreign affairs, currency and coinage, war and peace, atomic energy, national resources, preventive detention, railways, posts and telegraphs, national highways, institutions of higher education, etc. Thus, the nature of entries in this list is such as need a uniform law for whole country. Article 246, Clause 1 of the Constitution confers on Parliament an exclusive power to make laws with regard to any of the matters in the Union list. The states are not entitled to make any law in this area. Article 246, Clause 1 opens with the words, notwithstanding anything contained in Clause 2 and Clause 3 of Article 246. It simply means that if any matter is within the exclusive competence of centre, that is list first, it becomes a prohibited field for the states. The state list enumerates 66 entries and on which the state legislature can legislate, and such laws operate in the territorial limits of the state. Some of the main subjects of the list are public order, police, prisons, local government, public health and sanitation, communication, agriculture, divorce, marriage, etc. The concurrent list comprises of 52 items. These items include criminal law, criminal procedure, education, forests, etc. Here, both the centre as well as the state can legislate over the matters. However, the state's competence to legislate in List 3 is subject to the rule of repugnancy contained in Article 254 of the Constitution. The rationale underlying the concurrent list is that there may be certain matters which are neither of exclusive national interest nor of purely state or local concern. These matters are such that both the centre and the states may have common interest therein. Now the residuary powers. The Constitution under Article 248 vests the residuary powers of legislation with the Union. The article states, the Parliament has exclusive powers to make law with respect to any matter not enumerated in the concurrent list or state list. Such a power shall include the power of making any law and imposing a tax not mentioned in either of these lists. Constitution of India thus reflects a clear-cut division of powers between the Union and the states by following Canadian model. Now, dominant position of Union in respect of legislative powers vis-a-vis states. While demarcating for the Union and each state a separate and autonomous area of legislative powers along with a joint area of concurrent legislation, the Constitution nevertheless shows a leaning in favor of Union, which is evident from certain points like primacy to the Union law in respect of concurrent subject. Parliament and each state legislatures can enact laws over the items enumerated in the concurrent list. However, in case of conflict between the Union law and the state law, the law passed by the Union government gets primacy over the latter. Article 254 clearly lays down this principle. However, there is one exception, that is, if a state legislature has passed any law on a concurrent subject and has secured the presidential assent over it. In that situation, it can continue to operate in that state irrespective of the fact that it or any part of it is repugnant to any union law. However, here too, it has been laid down that nothing shall prevent Parliament from enactment at any time any law with respect to the same matter, including a law adding to, amending, varying or repealing the laws so made by the state legislature. Thus, the Parliament enjoys supremacy over the subjects of concurrent list. Parliament's power over the state legislatures. The state legislatures have the power to legislate over the state lists. However, here too several exceptions prevail which enable the Parliament to legislate over the state subjects in several cases. For instance, Parliament's power under Article 249 to legislate on any item which assumes national importance. Central legislation during emergencies. Whenever an emergency is declared, the Parliament gets the power to make law over the subjects enumerated in the state list. In such a case, that state list virtually gets transformed into concurrent list. Introduction of some state bills with prior permission of the President, like bills pertaining to trade and commerce within the state. Central legislation for giving effect to international agreements. Under Article 253 of the Constitution, the Union Parliament has the power to make any law for the whole or any part of territory of India for implementing any treaty agreement or convention with any other country or any international treaty. Superior status of Union laws. Under Article 251 of the Constitution, which provides that in case of a conflict between Union law and a state law, the former shall prevail over the latter. This provision gives a distinct superiority to the laws made by the Union Parliament, and Parliament has the power to determine or change the boundaries of the states. Repugnancy between the laws made by the Parliament and the state legislatures. Under Article 251 and Article 253, which deal with the repugnancy between the centre laws and the state laws, Clause 1st of Article 254 provides that if any provision of a law made by the state legislatures is repugnant to any provision of a law made by the Parliament, which Parliament is competent to enact, or to any provision of an existing law with respect to any of the matters enumerated in the concurrent list, then subject to the provisions of Clause 2, such a law made by the Parliament, whether passed before or after the law made by the state legislature or the existing law, shall prevail, and the law made by the legislature of the state shall, to the extent of repugnancy, be void. Article 254, Clause 1 applies only where there is inconsistency between central law and the state law related to the subject mentioned in the concurrent list. The most common application of this provision arises when both the central law and the state laws happen to be with regard to the same subject matter in the concurrent list, and there is repugnancy. Because of Article 254, Clause 1, the power of the Parliament to legislate in regard to the matters in List 3rd is supreme. Article 254, Clause 1 gives overriding effect to the provisions of the law made by the Parliament, which Parliament is competent to enact. A law made by the state is void if it is repugnant to the central law. Article 254, Clause 1 lays down the general rule, whereas Article 254, Clause 2 is an exception to the general rule contained in Article 254, Clause 1. Article 254, Clause 2 provides that where a state law with regard to the matter in the concurrent list contains any provision repugnant to the provisions of previous central law, with regard to the matter, the state law prevails in the state concerned, if it has received the assent of the President. The result of obtaining assent would be that so far as the State Act is concerned, it will prevail in the state and overrule the provisions of Central Act in its application to that state only. Now, the test of repugnancy. The repugnancy between the two statutes may be determined on the basis of three principles as discussed by the Supreme Court in Deep Chand versus State of Uttar Pradesh. Whether there is direct conflict between the two provisions, whether the Parliament intended to lay down an exhaustive code in respect of the subject matter in question, whether the law made by the Parliament and the law made by the state legislature occupy the same field. Consequences of repugnancy. When there is conflict between the state law and the central law, then the whole of the state law is not invalid. It is void only to the extent of repugnancy. When the inconsistent part is severable from the other provisions, doctrine of severability would apply. State law remains void as long as inconsistency continues. Once inconsistency is removed, the state law is revived. Now, the judicial attitude in the interpretation of legislative powers. In the process of interpretation of powers allocated to the Union and the states, the courts have evolved certain principles. Some of them are doctrine of ancillary powers. Legislative powers carry with it all the ancillary and subsidiary powers. Thus, a taxing power includes all ancillary powers necessary for the prevention of evasion of tax, harmonious construction. Some entries in different lists may overlap or even conflict with each other. In such case, it is the duty of the honorable courts to reconcile them and bring about their harmony. Now, the doctrine of pith and substance. Parliament or state legislatures should keep within their domain assigned to them and not to trespass the domain reserved for the other. To adjudge whether any particular legislation is within the purview of one legislature or the other, it is the pith and substance of the legislation in question that has to be looked into. This doctrine envisages that legislation as a whole be examined to ascertain its true nature and character. To ascertain the true nature and the character of the legislation in question, one must have regard to it as a whole, to its objects and to the scope and to the effect of its provisions. If, according to its true nature and character, the legislation substantially relates to a topic assigned to its legislature which has enacted it, then it is not invalid merely because it incidentally encroaches on a matter assigned to another legislature. The fact of incidental encroachment does not affect the vires of the law, even as regards the area of encroachment is not altogether forbidden. The doctrine of pith and substance for the first time was applied by the Privy Council in State of Bombay versus F.N. Balsara. The Bombay Prohibition Act, which prohibited the sale and possession of liquors in the state, was challenged on the ground that it incidentally encroached upon import and export of liquors across customs frontier, a central subject. It was contended that the prohibition, purchase, use, possession and sale of liquor will affect its import. The court held the act valid because in its pith and substance it fell under the state list and not under the union list, even though the act incidentally encroached upon the union powers of the legislature. Doctrine of culpable legislation. This doctrine is based on the maxim that what cannot be done directly cannot be also done indirectly. The doctrine becomes applicable when a legislature seeks to do something in indirect manner what it cannot do directly. In KCG Narayan Dev versus State of Orissa, the Supreme Court explained the meaning and the scope of doctrine of culpable legislation. If the Constitution distributes the legislative powers among us different legislative bodies which have to act within their respective spheres marked out by specific legislative entries, or if there are limitations on legislative authorities in the shape of fundamental rights, the question arises as to whether the legislature in a given particular case has or has not, in respect to the subject matter of the statute, transgressed the limits of the constitutional powers. Such transgression may be patent, manifest, direct, but it may also be disguised, it may be covert or indirect, and it is to this later class of cases that the expression culpable legislation has been applied in the judicial pronouncements. In other words, it is the substance of the act that matters and not merely the form or the outward appearance. And if the subject matter in substance is something which is beyond the powers of the legislature cannot violate the constitutional prohibitions by employing indirect methods. Concluding the topic on the legislative relations between the centre and the state, it becomes clear that there is defined, clear-cut distribution of legislative powers between the centre and the state, tilting more towards centre. However, the Honorable Supreme Court of India has done a marvellous work to facilitate smooth running of the centre-state relations by keeping a strong watch that both the union legislature and the state legislatures function within the allotted spheres. In the process of interpretation, the judiciary evolved and applied certain doctrines and thereby tried to maintain seriously the scheme of distribution of legislative powers which was established by the makers of the Constitution. Hope you might have understood and enjoyed the lecture. Stay healthy, stay blessed. Thank you.